Hi, my name is Narendra Kumar and again I am coming with the most wanted topic for arrest under GST law. So there are a lot of rumors about arrest under GST law, and usually department used to use as a beacon that you will be arrested, you will be detained by the department, but truth is different. Now the power of arrest under GST Act has been minimized to the maximum extent because it violates the fundamental right of our citizen slash the individuals. So this has been very minimized. So how power has been given? As per CGS section 69, the power of arrest has been given to the commissioner, and only commissioner is being empowered to order for the arrest only in case of serious tax evasion, which is now 5 crores. So if your tax evasion is determined by the department, not suddenly by just giving you the notices, by the investigation, they have a reason to believe that you have done something wrong against law, and that limit is of 5 crores. In other case, it's 2 crores, 2 to 5. There are several provisions is given, 1 to 2, 2 to 5 and 5 plus. So the notification which is issued by Ministry of Finance, CBIC, and also by the department. So there are following conditions which needs to be met before they order, and me remember that 2 crore is the minimum amount of tax evasion, whereas they have a reason to believe. So how you can be arrested? If supply of goods is without invoices, means you have supplied goods and it has been detained by the department and tax amount is above 2 crores, then they have a power to issue you for the arrest. Arrest can be also released on the bail, that will discuss separately. Supply of goods without actual supply of goods. This could be also a case that you are supplying goods without actual supply of goods, means it's a dummy supply, it's just invoices has been raised, e-bill has been raised, transporter has been hired on paper, everything is on paper, everything is bogus. This is a serious offense in GST, and input tax has been taken on the basis of fake invoice, means no real purchase or real supply of goods has been taken from your vendor. GST collected but not deposited. So these are the only 4 cases whereas you can be arrested. We will discuss about the bail condition, that is different, but amount is above 2 crores for arrest, and for bail, non-bailable offence, that is above 5 crores. Now CBIC has issued guideline on 17 August 2022 via notification number 2 2023 investigation being that regard they have specified under what circumstances bail in relation to offence can be given, which offence is punishable under CGST Act, and further instruction has been given by notification number 3 2022-23. So everything has been specified about power of someone under section 70 of CGST Act. Also guideline for arrest and bail relations to offence under CGST Act has been also issued very clearly to investigation department and also to the local judicial officer, that board has decided that following guidelines on aspect with the GST and arrest has to be given, that condition precedent to arrest. So what is condition precedent to arrest, that we will discuss, and procedure of arrest, means arrest can be done by giving ample opportunity to the offender or to the alleged person so that they can call to your relatives and friends that they have been arrested or they are likely to be arrested by the GST department. And what are the post arrest formalities, that they need to do panchanama and all, that the document has to be signed. So all such reports need to be prepared. We will refer to a judgment in case of Make My Trip by Delhi High Court. They have clearly prescribed about the arrest under the tax law, that under which circumstances GST department can use subsection 5 of section 135. So that means GST department are required to inform the ground of arrest, why they have a reason to arrest, and they need to produce before magistrate within 24 hours of arrest. So let's talk about one to one. What are the arrest provision under CGST Act and how can you take bail after arrest under GST provision? So you need to know, first of all, before you think about the vendor compliances, make sure that you have worked out with the right form, and if a reason of arrest for non-cognizable offence, available offence, then deputy commissioner or of CGST or assistant commissioner can release you on the bail subject to the provision of officer in charge, which is prescribed under 437 of CRPC. So they have the same provision. So if offence is available, they can arrest you of course, but they can release you on the bail. The same time they will release you on the bail. So, is there any limitation for arrest for tax theft or tax fraud? Yes, there is a limitation for arrest. Arrest can be only done when there is an offence of amount is more than 2 crores. Below 2 crores, they cannot arrest. It's a available. You just simply go on it. They don't have discretionary power that they cannot give you bail. They will have to issue the bail for you, and they will require to show you the evidences, and further investigation will take place. There are several judgments, so we will refer to only one judgment, that is Siddharth versus State of Uttar Pradesh. This is a very recent judgment, 2021. So, complete condition precedent to arrest has been given. For an example, commissioner should have a reason to believe based on the credible material. It should not be a just reason and they have concluded that you should be arrested. They should have complete material that supply of goods has been done without issuing of invoices, as we discussed earlier also. You have done fraudulently availing of input tax credit which is above 2 crores. So, there are several questions which are coming in the mind of consultant that I am handling my client case. Can a CA or advocate be arrested? My reply will be no, they cannot be arrested when you are filing GST return of your client. Arrest of a CA advocate is wrong absolutely, because you are acting in the professional capacity. You are providing GST returns. You don't know the actual intent of client, actual intent of your business. The landmark judgments have been given by the Punjab High Court in case of Akhil Krishna Murgu versus DGGI. So, this judgment is a very detailed judgment about the role of consultant and in the way of consultant should be appear. So, let's talk. You have a notice of section 70 and you have a fear to arrest. Then can you apply for anticipatory bail under section 70 for offences under section 70 of CGST Act? Yes, you can apply for anticipatory bail as the normal CRPC is applicable. So, you can apply to Metropolitan Magistrate or Session Court of in the district you receive. Also, you can apply for regular bail or you can apply for interim bail. This is dependent on the situation. Sometimes power of bail is with GST officer, which is pre-depository powers. Let's say in case of Orient Security Solutions versus Commissioner of CGST Act Delhi. So, there is High Court has granted anticipatory bail, and the tax obligation was 11.5 crores. On payment of 5.5 crores, they said okay, court has allowed anticipatory bail. Supreme Court allowed anticipatory bail to the petitioner in another matter by saying that okay, you need to deposit 10% of disputed liability. Let's say department is saying that you need to pay 10 crores taxes. If you pay 10% of the taxes, you are entitled for bail. Because bail is your fundamental right, as our lawmaker of our constitution believes that bail is the fundamental right. So, what is Supreme Court stand on arrest by GST officer? Another judgment which I can refer you to read, that is Sanjay Mukesh Bhai Patel versus State of Gujarat. This is very recent judgment on 13 July 2022. The bench has decided that merely because of section empowers GST officer to carry investigation and arrest the accused who they have a reason to believe that they have saved the taxes or they have escaped the taxes. So, power should not be used against the fundamental right guaranteed under the Article 21 of the Constitution of India. This article is very, very broad. So, if you see this, your rights has been violated, you can move to Supreme Court or respective High Court for filing writ petition, and I am sure you will have some relief if you are genuine. If you have done something wrong, then I must advise you that you should accept your mistake with the department, pay taxes, and this is the only available opportunity with you, or else you will face a lot of challenges, lot of complications. So, better to do business in the right way and pay taxes on time, pay taxes in the right manner. If you wish any consulting related to GST proceedings, GST cases, GST appeal, GST bail under GST and other advices which you think that you need to take, feel free to contact info@enterslice.com or visit our website www.enterslice.com. Please like our channel, subscribe to channel, and also comment with your thought. If you have any further question about this, how you can move ahead by filing writ petition to Supreme Court or High Court in case of arrest in GST, we can help you. Thank you very much for watching.